Good afternoon, everybody. Am I audible?
Yes, sir. Good
Okay.
afternoon.
Thank you. Thank you. Thank you.
I just a second. Uh, am I audible?
Yes, sir. You are audible.
A second. I don't know why the camera is not starting. It should. Ah, something. My lord, an absolute pleasure. Sorry, technical glitch at times.
Good afternoon, Kapilji. Good afternoon. We can see and
Such
hear
a
you. Good afternoon.
such an absolute pleasure. I don't know why, but it seems that the Mac is only taking the camera from my phone. Bharat is the tech whiz here. He would definitely know what to do.
Bharatji, good afternoon.
Hi, good afternoon, sir.
Good
Good afternoon.
afternoon. Yeah.
Hi, Kapil.
Good to see you, Bharat. What a
Good to see
pleasure.
you too, sir. Absolute honor, sir. Thank you.
Yes, Rayani. I think
Yeah, you
everything
can
is fine.
start.
Sure. Good evening to one and all present here, and welcome to day 4 and the final day of the second Sankhla and Associates National Virtual Moot Court Competition. To begin with, the mooting journey of a law student is a transformative odyssey where arguments become weapons, research turns into a compass, and conviction evolves into advocacy. And as John Doe propounded, that mooting journey of a law student is the crucible in which legal minds are forged, and it is in the heat of this trial that they discover the true power of their words. Today, I am filled with profound appreciation and esteemed delight as I find myself in the company of such distinguished individuals on this occasion. And with a heart heavy but an extreme amount of forward looking attitude, I, Rayani Bhattacharya, officially welcome you to the valedictory ceremony of the second Sankhla and Associates National Virtual Moot Court Competition 2023. This event has been a journey of intellectual exploration, a testament to our steadfast dedication and passion for the legal domain, and a celebration of the power of collaboration and the ability to persevere in the face of adversity. The amicus curiae proudly asserts its position as an unparalleled legal platform renowned for its remarkable swiftness and efficiency. In fact, from its very genesis, the noble pursuit of moot court activities has resided atop the lofty summit, driven by the noble ambition to cultivate and nurture the budding legal intellects, adept and at ease in navigating the intricate tapestry of diverse legal systems and cultures that collectively constitute our interconnected global society. Speaking about our co-partner, Sankhla and Associates of this National Virtual Moot Court Competition, Sankhla and Associates is a global commercial and corporate law firm in India. The law firm has top lawyers from India, the UK, and Singapore. Since the commencement of this illustrious contest, our lofty aim has not simply been only to partake in a contest of skill, but rather to advance and to be more exact, to cultivate our understanding of the law, to augment our expertise in persuasion, and to achieve mastery in the crafting of compelling discourse. We have intended to magnificently showcase the indomitable fortitude of our unwavering commitment, the undeniable fact that we have triumphed over obstacles such as multiple regions, technological predicaments, and the absence of a physical courtroom is a testament to both our adaptability and our unwavering pursuit of victory. Furthermore, we embarked upon this undertaking with the intention of our participating teams to enhance their understanding of the intricate fabric of the legal system, sharpening our persuasive prowess and achieving the pinnacle of proficiency in the craft of constructing a compelling and indisputable argument. By virtue of the steadfast devotion, I can proudly assert that the teams have successfully showcased the unconquerable fortitude of their allegiance, overcoming the formidable challenges that emerged as a direct result of their toil within the digital domain. And this surely would not have been possible without the unwavering support from several of our well-wishers. A huge round of appreciation awaits our sponsors for the second edition of the Sankhla and Associates National Virtual Moot Court Competition, namely Chambers of Abhinav Mishra, GL Parekh Chambers of Law, Adroit Links, Chambers of Advocate Radhika Singh, and Chambers of Advocate Rishabh Raj. I would also like to take this opportunity to appreciate and thank all our knowledge and media partners for promoting us and showing their incessant support through the perks and privileges that has been granted to the participating teams. Henceforth, devoid of any further delay, I would take great honor to call Mrs. Lisa Dutt Singh, our guest speaker, founder and managing partner of Adroit Links, to address our audience. Lisa ma'am has worked as a corporate lawyer for 17 plus years, and her past work experience includes working with corporates like excelservice.com Private Limited, Innodata Isogen Private Limited, Clairvolex. As a seasoned and experienced attorney, Lisa ma'am excels at simplifying compliance. She also has an extensive experience in conducting POSH training and ensuring POSH compliance. She is an external member with the internal committee under POSH law with several corporates and educational institutes, and an accomplished trainer as well. She has trained more than 500 plus lawyers on various legal regulations and POSH. As a lawyer, Lisa ma'am has a deep understanding of the legal framework that surrounds sexual harassment, including the legal rights of employees and positions in various corporate legal departments. Ma'am enjoys advising organizations on legal and compliance matters, which involves advising and drafting of policies and contracts, vetting and reviewing, negotiating, conflict management and dispute resolution, and strategic advice in managing legal issues. Ma'am, it's an absolute honor to have you among us, and we can't wait any longer to hear from you. Over to you, ma'am.
Thank you, Rani. That has been quite an elaborate introduction. Thank you so much for giving me this opportunity. So, a very good evening to all of you, ladies and gentlemen, distinguished guests of the ceremony and participants of the second Sankhla and Associates National Virtual Moot Court Competition 2023. Today, as we come together to celebrate the culmination of the second Sankhla and Associates National Virtual Moot Court Competition 2023, I am deeply honored to be a part of this momentous event, and I extend my heartfelt gratitude to the organizers for inviting me to address this exceptional gathering. To all the participants, I want to start by saying that you have embarked on a remarkable journey, one that will leave an enduring mark on your legal careers. It's a moment to reflect on the countless hours of preparation, the sleepless nights, the camaraderie forged through teamwork, and the invaluable lessons learned along the way. Moot court isn't just about legal arguments, it's about dedication, perseverance, and pursuit of justice. The moot problem that you grappled with centered on the constitutionality of sedation laws, Section 124A and other penal laws, which delves deep into the heart of contemporary legal challenges. These are not just theoretical debates. They touch the very core of our democratic principles. I want to talk to you today about the essence of what you have experienced, regardless of whether you are holding the winner's trophy or dealing with the disappointment of elimination. What you have achieved in this competition is far more than just a score or a ranking. It's about the skills you have developed, the knowledge you have gained, and the spirit of resilience you have cultivated. To the winners, I salute your exceptional dedication and hard work. Keep up the good work. Your victory here are a testament to your ability to navigate intricate legal scenarios and craft persuasive arguments. Your success is a source of inspiration for all, demonstrating that perseverance and determination have paved the path to your victory in this competition. To those who have faced setbacks and didn't make it to the finish line, remember this. Setbacks are not failures, but they are stepping stones to success. In the legal profession, as in life, adversity can be a powerful teacher. It teaches us resilience, the ability to adapt, and the importance of learning from every experience. As budding legal practitioners, you are on a journey that extends far beyond this moot court competition. The skills you have honed, constructing compelling arguments, thinking on your feet, and understanding the complexities of the law are invaluable assets in your future legal careers. Irrespective of whether you choose to be a litigating lawyer or a corporate legal counsel, the experience and skills you have gained here will serve you well in courtrooms, boardrooms, and in shaping the society we live in. The legal profession is a calling, it's a vocation dedicated to justice, fairness, and safeguarding individual rights. It's a huge responsibility. You have chosen a noble path, one that requires unwavering commitment to the principles of justice and the rule of law. Your role in shaping the legal framework of our society is profound and far reaching. Please always remember that. As you move forward, remember that the pursuit of justice is not just a job, it's a lifelong commitment. You have the power to make a difference, to uphold the Constitution, and to protect the rights of every individual. Embrace this responsibility with the knowledge that your dedication will contribute to a more just and equitable society. In closing, I want to reiterate my gratitude to the organizers for this opportunity, and I want to leave you with the thought your journey has just begun and the legal horizon is limitless. Keep your passion alive, never stop learning, and always remember that the pursuit of justice is a noble and rewarding path. I have every confidence that each one of you, whether you have tasted victory or faced challenges, will continue to shine brilliantly in the world of law. Your journey is a testament to your dedication, and I have no doubt that your aspirations and commitment will lead you to remarkable achievements in the legal realm. As we gather here today to mark the conclusion of this incredible journey, may your passion for justice continue to burn brightly in your hearts as you embark on this incredible journey in the world of law. Thank you, and let's continue to make a difference in the world through the power of our knowledge, our wisdom, our courage, and uphold justice. Thank you so much.
Thank you so much, ma'am, for sharing your enlightening words of wisdom. In fact, it reminds me of a quote by Winston Churchill. That he says that success is not final, it's failure is not fatal, but it's the courage to continue that counts. So really appreciate your remarks, and I'm sure that the participating teams are thrilled by them. Moving on, I would like to take this moment to call upon our guest of honor, Mr. Bharat Chuk, founder Chambers of Bharat Chuk, to enlighten us with his kind words of wisdom. Bharat sir graduated in law in 2011 and in 2013, and at the age of 23, he secured the first rank in Delhi Judicial Service exam and was appointed as a civil judge or metropolitan magistrate, where he served in various judgeship assignments in the 4 years that he spent at the bench. In 2016, he resigned from judgeship and returned to practice law. Bharat sir has served as a partner at L&L Partners, formerly Luthra and Luthra Law Offices. He has served on various committees or policy discussions, and has also been appointed as amicus curiae by the High Court to assist the court in some serious criminal cases. He is also a part of the Young SIAC steering committee. Bharat sir is a guest lecturer or resource person at various academies and has conducted training programs for aspiring and serving judges, IPS officers, investigators, prosecutors, arbitrators, defense counsels, etc. Bharat sir currently practices as an independent counsel and heads the chambers of Bharat Chugh. It's an absolute honor to have you amongst us, sir, and we can't wait to hear from you. Over to you.
Thank you very much for having me. An absolute honor being here today and sharing the same space with legends like Justice Menon, Kapil sir, and Miss Singh, amongst others. So thank you very much for having me. I feel utterly unqualified, because my experience and my journeys have not been as rich or diverse or as wide as some of the other dignitaries on the panel. You'll have to bear me out on that. I say this with repetition, and I really look forward to. I really enjoyed Ms. Singh's, very insightful talk, and look forward to hearing Justice Menon and Kapil sir. But the last 11, 12 years that I've spent in the legal profession, and it's not certainly very long. When I Justice Menon, for instance, that I was just saying, graduated in 1981, if I'm not wrong. So the sheer expanse and the rich experience that he carries would be very, very insightful for all of us. I spent 11, 12 years. And since law is a marathon, not a sprint, it's not a very long distance. And but in the last 11, 12 years, even if I've not been able to gather what to do, I've been able to pick up a few things on what should not be done, in the art of advocacy. The last 11 years that I've spent in the legal profession, about 3.5 years, as you said, were spent as a trial court judge, and some amount of it as a lawyer for the victim and for the accused. And I think in this has been a beautiful decade. So I'll just share with you very, very quickly, about 6, 7 small short points, in a bullet point form, because, I'm sure you have better things to do, on this evening. So I wouldn't subject you to more time than necessary. And, the lawyers have this problem. We can write a 1,000-page document and still call it a brief. So brevity and precision is not something that sort of comes naturally. So I'll try to be as brief as possible. Number one, these are my learnings from the little that I've mooted and the way I've tried to understand litigation and the art of advocacy. I'm glad this is happening, and people are mooting as much as they are now. I love to say that mooting is like being in a bouncy. Even if you jump and you fall, you don't get hurt. It's as close to a real courtroom that you can get. You may commit mistakes, and nobody's going to jail for it. Mercifully, nobody's losing $1 million in an arbitration for a mistake committed. A very great opportunity to sort of learn. My points to you are as follows, okay? And please give me a signal when I'm out of my 10 minutes. Number one, just reading the brief is not enough. The problems that sometimes we commit as young people is we read the brief, but we do not think about it. So always have the moot problem or the brief that you're working on. Close your eyes, take a step back, think about it, visualize, anticipate, make it come alive with examples. Go for a walk and think about the various questions that may be put to you by the bench or the opposite side and the kind of arguments that they may take up. Sometimes we prepare our brief so well that we do not prepare the opposite side's brief. Understanding the adversary's case, distinguishing their case laws, distinguishing their arguments is very, very important. And Justice Menon would bear me out. The best counsels in the business are people who do not only state their case positively, but also preempt the case of the opponent and take the sting out of it. And be fair as a counsel. We'd love to say this, that we as counsels are officers of the court before we are counsels for our clients, right? What does that mean really? That means that you have to concede bad facts, you have to concede if the law is against you, and then still try to make the argument that you are trying to make. And you have to assist the court on the law dispassionately, objectively, and as a true officer. You should not be seen to be misleading ever. You're not the mouthpiece of your client. You are not supposed to just say what your client tells you to say. You have a credibility and reputation that outlives one case. And reputation and integrity in the longer run, you'll find out, is everything that you have as a lawyer. So very, very important. Prepare well, think about your brief, be fair, make those reasonable concessions. You have to be very, very honorable and reasonable as a lawyer for you to command credibility. You should have credibility to an extent where if you are telling the honorable court that page 69 says what you are saying it says, and the court does not feel the need to go to page 69 or a 49 and to then see what is there, that should be the trust and credibility that you command. Very important again that you prepare and leave nothing to surprise. There should be nothing in the court that should unhinge you. You should have thought of the multiple possibilities that may come up in a case. What if the opposite party seeks an adjournment? What if the opposite party files a interim application to unhinge you and dislodge you and bring up something new? So, thinking out of the box, thinking on your feet, anticipating and visualizing is key to advocacy. And remember, when you're arguing, it's much more than the case file. When you argue a case, you bring to the table your lived experiences, your understanding of life, economics, policy, sciences, and most importantly, human beings. I think in law, the most important thing is to empathize and to be able to understand what the others think, the quality of otherness, the ability to get out of your own skin and walk in somebody else's shoes and skin, and trying to understand. Because when you're arguing, you're dealing with a human being at the end of the day. My father used to tell me that never try to argue your case right before lunch when the judge hasn't had anything to eat for the last 6 hours. Now that has profound merit. We in a we would take a step back and think, that doesn't really influence anything. A judge would decide on the basis of evidence and law and facts and merit. But there are things that play on mind. There is something known as decision fatigue. If, for example, you've been sitting for 6 hours without food, and you have difficult cases, you've already decided 50 cases on a given day, decision fatigue sets in. And there are scientific studies that prove that the amount of glucose in your blood and your system goes down, and your ability to take difficult decisions also goes down. So, there's this Israeli study, a very fascinating study, that says that if your matter has come up right before lunch, then your chances of getting a parole go down incredibly. And they've tried to measure it up with facts and evidence. Now the jury is out on that. But all that I'm trying to say is that since you've taken it upon yourself to be advocates and litigators, and you've taken it upon yourself that your business in life or your profession in life is to persuade people on your narrative and to convince somebody who's taught not to believe in you. And if that is what you've taken on yourself, it is very, very important for you to try and understand people. And why do people act the way that they do? What are the incentives? And also anticipate and try to take a step back. And much of this you'd learn in the university of life more than any other books. These are some of the things that you would not pick up in a library. Like, you cannot learn to swim in a library. You'll have to put in the hours, you'll have to learn and absorb, you'll have to sit in the courtroom the whole day and just absorb whatever is happening, learn from other people's mistakes. And in all of this, since we're young and we cannot really acquire those experiences, and experience would come when it does, I think reading is a very good proxy for living. Sometimes you can experience somebody else's life, how other people think, the quality of otherness from reading. And that is why somebody has very wisely said that reading is proxy to living. Reading is the only way that you can live multiple lives in a short span of your own life. Reading is the only way. And when you have read a great book by somebody phenomenal, you learn to stand on the shoulders of giants and benefit from their experiences and their mistakes and harvest those great minds that are there in the book. Learn from their mistakes and triumphs.
किस हीरोइन का कौन सा वाला गीत आप सुनना चाहेंगे?
So I just request Sankalp there to thank you very much. So reading is very, very important, in advocacy, as Justice Menon, Kapil and Ms. Singh would testify from their experience. It gives you the vocabulary, it gives you the ability to make a precise and nuanced point. And words, after all, are the stock in trade of a lawyer, right? You and I don't sell any tangible good or service in the sense that other people do. So we work with words and ideas and interpretations and facts. So very important for you to work on your language and your ability to interpret. And very important is to lead also an examined life. And this is the second last point that I make. Law is a lot about storytelling, and advocacy is a lot about storytelling. But when I say you have to be a great storyteller, I do not mean that you can be a storyteller in the form or manner that a novelist is or a writer of fiction is. You do not take liberties with facts as a lawyer. Facts are facts. You may be entitled to your own opinion, but you are not entitled to your own facts. So you take the facts and evidence as it comes, but you can choose to, and this is where the mastery and creativity of a counsel is, that you can choose to put the same facts in an order or in a format which is interesting for the reader to absorb and to grasp. A single case can be put in so many different words. For example, a counsel starting his arguments by saying that I stand or I represent today an 80-year-old widow whose house has been demolished. If that's your first line, then your chances of getting an audience would go up, because you've not wasted those first 5 seconds. And very senior counsel are here, they would tell you that in a Supreme Court or on the High Court on a miscellaneous day, 5 seconds or 10 seconds is sometimes the only thing that you'll get. Sometimes the moment it takes you, or the time that it takes you from walking to your seat to the dais, your file would already be dismissed. And then it would be your craft and your skill to have the bench look into the matter. I was doing this matter in Aurangabad, where very interesting question of a general law versus a special law. And the time that it took for me to walk up to the dais, the honorable bench had already thrown the file away and said, dismissed, we are not issuing notice. Now, there are different responses as an advocate to a situation like that. One, I can take it upon myself that, no, this is unfair, this is unjust, I should be heard. Or I can try and understand that the bench has 150 cases today. And if they grant an elaborate hearing in every case, they may not be able to dispose them off, and they have come having read the files. So, there are different ways in which you approach. So what we did, and I learned this from my seniors, that, I said that I did exactly what my lords have done. I thought the case had no merit. And when the client came to me, I told them, you have no case, and I almost threw the file exactly the same way. But then I looked at page 49. Now, this is a case that is covered by a direct judgment. And then you succeed, or you convince them into picking the file back up. Why? Because you connected with them on a human level. You've recognized the fact that they're not wrong in thinking that this is a patently meritless case. Any reasonable person would think like that, but there is more to it than meets the eye. And I am going to demonstrate that. If you just give me 30 seconds, then I'll make my case good. The different ways that you'll find out, as you go along mooting and in this journey. Preparation, again, is a very important point. Preparation is everything. There is nothing known as luck. Luck is the exact point where preparation meets opportunity. You're very prepared, you get an opportunity. That's the definition of luck. Nothing else, in my humble opinion. Prepare your cases like elevator pitches. Nobody has the luxury of time and a thoughtful consideration in that sense. So prepare your case like you can summarize. And most difficult cases, howsoever complicated they may look, can be summarized effectively in 45 seconds or a 30 seconds or a 60 seconds, depends on how you do it. So please keep that in mind. Hardly ever any hearing goes as per a script. You have to be prepared for the bench not willing to listen to you at all, and for you to only answer their questions. So be prepared for those things. Don't go by a script at all. And also remember that being a great lawyer is not about being argumentative. A general misconception that, the kid is very argumentative, make him a lawyer. But I think the most arguments are won or lost mostly by silence. And, sometimes in a younger days, we do not understand the importance of not saying as much. The best questions in a cross-examination, for instance, are the questions never asked. So silence is very important. Cultivate strategic silences. Benefit from the power of a pause. You need not fill every minute with sound and words. So important is that. Also, sometimes an opponent is going to be their own worst foe. And when you see that happening, you should fight without fighting at all. As Bruce Lee said, that the best art of fighting is the art of fighting without fighting. You don't need to argue. If you see somebody, creating problems for themselves in their arguments. And that is where your role, and this circles back to what I said to you earlier, your role as a counsel and as an officer of the court and not as a mouthpiece of your client would become important. Because sometimes your client may want you to argue, even if it doesn't help him or his case. And sometimes as lawyers, we also tend to play to the gallery, where we know that our client is there and he expects us to fight and fight very aggressively. But that's not going to help him in the longer run. There you will have to take a step back and not do something just because your client wants you to, if it doesn't help him, number one, and second, if it is not helpful to the court, and your job is to assist the court on all points. And my last point today, and which is where I'll stop, please develop range and breadth. Be a multidisciplinary thinker. And you should not, and sometimes young people, they dig the trench of their own specialization too much. I would advise in the first few years, experience as many different practice areas as you can. If you want to be a litigator, do a constitutional law matter, do a bail application and injunction application all on the same day. Don't specialize too early in life. It would come to you at some point, but experience everything before you decide to sort of put all your eggs in one basket. And that's my short message to you. Thank you very much for having me and for organizing this. Congratulations to the winners and the organizing committee. And please keep up the great work. Thank you.
Thank you so much, sir, for your address and for sharing your experiences. Your tips, as you said, very distinguished, and I think it collectively it has really motivated all our young legal minds and a lot of things to take away as well. So I really appreciate the time that you've taken to address our audience, and I'm sure that the listeners have had confidence because of your remarks. Thank you so much. Moving on, I would like to take this moment to call upon Dr. Kapil Sankhla, our patron in chief for the second Sankhla and Associates National Virtual Moot Court Competition 2023, to enlighten us with his kind words of wisdom. Dr. Sankhla is the current managing partner of Sankhla and Associates, which he established about 20 years ago. He has been practicing since 1999 and received the 2016 Super Lawyer of the Year award. His background includes expertise in corporate and legal advice, litigation and arbitration, white-collar offenses, employment, infrastructure, public policy issues, governance, ethics, and policy. He has been an appointed attorney for several government agencies. His major customers are GAIL, DDA, DSIDC, Waqf Board in Chandigarh, Life Insurance and DJB, Indian Corporation, and various private enterprises like Shriram Life Insurance Business, DHI, India Water, SpiceJet Limited, etc. He has worked for the Ministry of Natural Resources and the General Directorate of Hydrocarbons in several international arbitration proceedings in the UK and against Reliance Petrochem and Cairn India. Sir, thank you so much for being here with us once again. Over to you, sir.
Thank you, Rayani. Only one thing, you've been very generous about my age. It's been 25 years to this craft now, but I still look young. And first of all, thanks to Bharat. It's always a pleasure listening to him. I've actually listened to a lot of his videos. And in my office on Saturdays, I actually tell my associates to listen to different recordings of different lawyers. Bharat is one of them. But to be here for the purpose as the patron of this prestigious second Sankhla and Associates National Virtual Moot Court Competition 2023, it is my distinct honor and privilege to address you all on this really momentous occasion. We reached the culmination of an event filled with legal acumen, passionate advocacy. I personally heard a lot of these young minds and their unwavering dedication, because I also saw that they were answering questions and they were sticking on to their guns. But first and foremost, I would like to extend my heartfelt gratitude to my Lord Justice Rajendra Menon, and also to Justice Mukta Gupta, who was our chief guest at the inaugural ceremony. Here at this valedictory ceremony, it is an absolute honor appearing once again before Justice Menon. He, of course, has been our chief guest of the Chief Justice of our High Court, and I've had the pleasure of appearing before him. Now, of course, he is the chairperson, National Armed Forces Tribunal, and it is always a pleasure, my lords. My lords have been renowned judges whose presence has added immense prestige to this competition. Your invaluable insights, and we're dying to hear you, my lords, and wisdom has undoubtedly enriched the experience of our participants. I will cut it short that I will leave the floor to you, my lord, so that I would have the pleasure of hearing to you as well. And also an absolute pleasure hearing and sharing space with my very, very good friend, Mr. Chup. Very, very eminent lawyer, wonderful academician, fantastic person. As far as the participants are concerned, I really have to say this, that we've observed a remarkable display of legal acumen, discourse, intellect throughout this competition. the second Sankhla Associates Virtual National Moot Court Competition 2023 has been a profound platform dedicated to allowing legal minds to come together and argue before the experienced professionals of this field. We do know that one of the guests who were invited as an arbitrator is also the special public prosecutor in the very question that was raised. This occasion has functioned as a testament to resolute commitment and unwavering devotion that every participant has exhibited. Every participating team here has undertaken absolutely wonderful, intricate legal matters, analyzed them with meticulousness, articulate, persuasive assertion, and honestly has left many of us astounded. This competition has shown once again that the legal domain requires not only profound understanding of the legislation, but also the ability to adapt to new challenges and perspective. The teams have exhibited their perseverance and adaptability in this digital environment, which the Honorable Supreme Court has been insisting that we now take care and adapt to really, really quickly, validating the legal profession that it is suitably equipped to thrive in any given situation. They have dared to test their own mettle, in fact, for no simple task to present oneself before our esteemed arbiters and endure their unrelenting interrogation, scrutinizing every aspect of veracity and jurisprudence. To the participants, thus, who have showcased their legal prowess and critical thinking throughout this competition, you're the future of our legal system, and your passion for justice is truly inspiring. Your hard work and determination are the driving force behind this competition's success. This also leads me to thank and acknowledge our esteemed arbitrators, the judges, whose engagement has equally contributed to the triumph of this competition, ensuring that they do not offer any leniency to the participating teams, thereby making sure to bring the best possible skills out of the participating team. I would also like to express my gratitude to the organizing committee, Rupam, especially to you, whose tireless efforts and meticulous planning have made this event possible. Your dedication to promoting legal education and fostering the spirit of competition is truly commendable. Last but not the least, of course, I would also like to thank the faculty of these young students, the mentors and the advisors who have guided and mentored our participants. Your guidance and support, thank you, have instrumental in nurturing the legal minds that we see here today. In closing, I want to emphasize the importance of events like these, especially these virtual events which are taking place, because these are shaping the future of our legal profession. It is through such competitions that we continue to uphold the principles of justice, fair play, and of course the rule of law. So once again, I thank you, the Honorable Chief Justice, for gracing us with your presence, and everyone here for their unwavering support. Let us look forward to the continued growth and success of this Sankhla Associates National Virtual Moot Court Competition with amicus. Thank you all, and may justice always prevail. Over to you, my lords.
Thank you, Dr. Sankhla sir, for your address. It is always a pleasure to hear from you, and we hope to hear from you very soon in a non-virtual setting. Thank you, sir. Moving on, it is my absolute honor to call upon Justice Rajendra Menon, our chief guest for the second Sankhla Associates National Virtual Moot Court Competition 2023 to enlighten us with his words. He is the National Chairperson, Armed Forces Tribunal, and former Chief Justice of Delhi High Court. Justice Menon started practicing law soon after his graduation and was associated with senior advocates P. Sadashivan Nair and Mrs. Indira Nair ma'am. He was standing counsel for central government from 1991 until his elevation to the bench in 2002, as well as for several private and public sector undertakings like Coal India Limited, Syndicate Bank, Union Bank of India, Vijaya Bank, Rani Durgavati University, etc. He was attested as additional judge of Madhya Pradesh High Court in 2002 and became permanent judge in 2003. He was in the Madhya Pradesh High Court's Gwalior bench till March 2008, then Principal Bench, Jabalpur. He was acting Madhya Pradesh High Court Chief Justice till 2017. He served on many administrative committees of Madhya Pradesh High Court and was appointed Bhopal Gas Victims Compensation Commission Welfare Commissioner from December 2010 until March 2015. From March 2015 to March 2017, he was in charge of Judicial Education and Training, MP State Judicial Academy, and MP State Legal Services Authority. On 15th March 27, he was appointed as the Chief Justice of Patna High Court and served until 7th August 2018. He was sworn in as Delhi High Court Chief Justice on August 2018 and retired on June 2019. He was assigned chairperson of the Armed Forces Tribunal in November 2019. Thank you so much, sir, for being here. Over to you, sir.
Good evening, everybody. Kapil, Bharat, Lisa, Upam, Raini, and all others present. It's a pleasure and honor for me to be here in the valedictory function of second Sankhla and Associates Moot Court competition. I've heard Lisa, Bharat, and Sankalp and Kapil, and I'm really, what to say, happy and honored to hear all of them. Particularly, as Kapil said, I would have no option but to agree with him that every student present here should have noted what Bharat has said. As a judge, I endorse them in toto, and I would recommend that if you have a recording of his speech, hear it again and follow on in letter and spirit each and everything he said. I feel his experience for 4 years in the bench and thereafter in the bar has made him feel the way he expressed before us. Kapil, it's really good on your part to have come forward and help Rupam and his friends with organizing such a beautiful competition. It gives an opportunity to the young, budding, upcoming professionals who will enter the profession to learn many things. I belong to a school or a period when law was not an option as a profession. We all became, or at least I can say that I came to this profession by default. As Lisa said, that you should not be worried or perturbed by failures. Failure is a stepping stone to success. And I am the biggest example for that. In as much as I wanted to become a doctor, I gave up my graduation for 1 year to become a doctor, couldn't become a doctor, and somehow I landed in this profession. And after 42 years, I am where I am today. So failure is not end of everything. In my view, failure is the road to success. So students, mooting is one of the best form of preparing yourself for the profession, particularly if you want to go into litigation as the primary goal in your profession. When we graduated in law, many of us did not know how the proceedings in the court go. It's only on the first day when we enter the court that we understand how to present yourself before a judge and how to start arguing a matter. But with the new legal education pattern which we have, thanks to one of the best legal knowledge person with legal knowledge and academics in the field, Professor N.R. Madhav Menon, who invented and who proposed the 5-year legal course, the legal education in the country changed. And that is how it started from the National Law University, Bangalore, and mooting and other internship systems came into force in the legal profession. I remember when I argued my first case in the High Court way back in 1981, it was before Justice J.S. Verma. And by the time I reached the dais to argue, I had forgotten everything I had prepared. But thanks to Justice Verma, he only asked me one question: what is your case? I said, sir, it's a case of dismissal after departmental inquiry. And he asked me, what is your main point? I said, it's discrimination. Two of us were put to the departmental proceedings, and the punishment meted to us is entirely different. There is discrimination. And he asked, what is the section in the Constitution relating to discrimination? I said, Article 14, and he admitted my case. And that gave me the confidence which brought me to where I am today. Friends, there is no shortcut to hard work. Law is a profession which needs 24/7 hard work. If you get time to sleep, you are lucky enough. Otherwise, you have to read, study, apply your mind, keep on thinking, even think while you go to bed as to what you have to argue tomorrow. Is there anything which you can add or subtract from your argument? And I always tell my young friends who want to enter the profession that understanding of human being, human psychology, and understanding the feelings of other is one thing which is very important for a lawyer. When a client comes to you, he does not come just because he wants to do something. According to me, 80% of the people go to a lawyer or a doctor because they feel they have a problem, and the lawyer or the doctor will help them in resolving that problem. And when a person comes to you with a problem, you are supposed to hear him with all the patience. You are not supposed to tell him that, yes, I understood, or I understand what you want to say, I'll take care of it. No, please listen to him. He will speak out from his heart, and once you know what his problem is, you will understand his difficulties more correctly, and that will help you in putting up his case in a better way before the court. I don't know if you have undergone mediation training. You have the 40 hours mediation training. If you undergo the mediation training, you are taught how to listen to the problem of a person and then understand the problem, not to interfere while someone speaks to you. Like that, you have to understand your client's problem. And as a lawyer, the most important aspect of advocacy, as Bharat said, is understanding your judge. Reading the mind of the judge. Understand him. Try to take him with you. And if he's not with you, try to bring him around and carry him with you. I can give the example of one of the stalwarts we had at one point of time, who was from my High Court, Madhya Pradesh High Court, Shri Rajendra Singh. Kapil would be knowing about him. He's one of the best criminal lawyers in the country, who became a member of the Rajya Sabha also. And I've seen him argue before the Chief Justice of India and also before a Tehsildar in a criminal matter pertaining to small thing. And I found he presents himself in the same way before a Tehsildar or a Munsif, the same way as he argues before the Chief Justice. And that is one quality which I found in him, and I imbibed it into me, because that gives the judge the confidence to believe you. Such a great man standing before me humbly and praying for his client makes the judge think differently. Arrogancy and just fighting with the judge or arguing with him without any reason will not take you anywhere. And how do you read the mind of the judge? Is he a convicting sort of a judge? Is he a liberal judge? How he thinks? The only way is to sit in the court and see how the proceedings go on. It's not that your senior has given you 2 cases, it's over at 11 o'clock, and then you have left the court premises and roaming around in some shopping mall or going for a movie. No. To begin with, your court timing is 10:30 to 4:30. Even if you have work or not, find out in which court, what case is going on, who is arguing, sit there, try to understand and learn from them. Once you sit there and see how arguments and proceedings take place, you will slowly develop the art of understanding the judge and reading his mind. You have, when you practice in the High Court, you have the roster. And as a client comes to you with a case, you will understand this case has to go to a particular judge. And if you want the stay, your stay application has to be drafted in such a way that you know the mind of the judge, what he wants, how will he react, and to that effect, your drafting has to be as per his liking. So understanding the judge is one of the most important art of advocacy. As Bharat said, you are an officer of the court and you owe a huge responsibility to the court merely because you are a brief holder of your client and he has paid fees to you. It's not necessary that you should present the case in a manner which is unbecoming of a lawyer. I can give you my own example, which made my Chief Justice call me and ask me to become a judge. My Chief Justice had come from Jammu and Kashmir. He was a new judge to the court. I was arguing a case for a bank, and the lawyer who was appearing for the employee argued the case in a particular manner, and the Chief Justice was about to dismiss the case. I stood up and told him that I am appearing for the bank. He said, "We are dismissing the case." I said, "Sir, it has to be allowed." He asked me why. I showed him 2 Supreme Court judgments, and in the evening, the Chief Justice called me and asked me, "What are you? Who are you? Give me your biodata." And after 1 year of testing me, he recommended my name for elevation when I was only 43 years of age. So what I mean to say is, as an officer of the court, you don't act as if you are holding his brief. You have to do justice to the case. And justice is not for your client. Justice is also for the other party who is not before you. He may not be your client. And whenever you argue a case and whenever a judgment is given, there are certain category of persons who are not before the court, but who would also be affected by that judgment. And therefore, justice has to be done to those people also who are not before the court. As a judge, when lawyers argue case before me and they ask me to do this and do that, I always tell them, I'm not here to do justice to both of you and the other, your respondent who is here, but I have to think of a third category of persons who are not before me and what would be the effect of any order or judgment that I pass, and I have to take care of that and do justice to them also. So when it comes to your duty as an officer of the court, you have to think about the reaction or the effect of a particular order on a category of persons who are not before the court. And you as an officer of the court owe a responsibility to the society to see that justice is done. Many times when I say so, lawyers tell me, "Sir, if we follow your advice, we will be briefless lawyers. The client will go away and we will be nowhere." I tell them a story of a senior advocate who appeared before a particular judge when I was a very junior lawyer. And the judge, it was a civil revision under section 115 of the Civil Procedure Code. And the judge said, Mr. Counsel, you are such a senior counsel. You know what has happened, and still you have come out with a case. There is nothing in your case. He said, sir, I know it. But when I told my client, he did not hear what I said. So I have affixed a court fee of 100 rupees. Please give your opinion. I'll pass it on to my client and he'll be satisfied. Now, by that, the lawyer discharged his duty as an officer of the court by not arguing unnecessarily, wasting the time of the court, and as Bharat said, playing to the gallery. There was another senior advocate when a judge said in an address to the Bar Association that when you judges tell us that we should admit that we don't have a case and not argue before you, he showed to the members of the bench the other side of the coin. And the learned senior advocate told the audience that once a client came to me, it was a case of a departmental inquiry where a charge sheet was issued to his litigant, and he wanted to challenge the charge sheet. He told him that in a petition under Article 226 of the Constitution, the High Court will not interfere at the stage of charge sheet, so please go away, don't waste your time. And the learned senior advocate said that, sir, after 10 days, I found when I was walking in the corridor that the litigant was coming from my opposite direction, laughing, and when he saw me, he said, sir, aapne to kaha case mein dam nahi hai, mujhe to stay mil gaya. So it was a pointer from the bar to the bench that there is inconsistency in the manner of deciding of cases also. Therefore, why should a lawyer suffer by giving an advice which ultimately may prove to be disaster for his profession? I have an advice or a solution for that. Yes, don't. If the client insists that you should file a case, file it. But when it comes to the court and you find that the court is hostile to it, don't keep on arguing and waste the time. Just close the file and say, Lordship, you may pass an order. That's all what I have to say. See, you have to develop your practice these days in such a manner that the judges and the members of the bench rate you as a fair lawyer, as a good lawyer who knows the law and is only interested in dispensation of justice in the best possible way. And once you do that, and once you earn a name or a reputation of being a fair lawyer, both to your litigant and to the bench, then I can tell you that if there is any discretion available with the judge, you will be the first person to get it. Otherwise, you will be branded as an arrogant and rude lawyer. And if there is any discretion that could be exercised in your favor, the judge would say, no, why should I do it to him? He doesn't listen to me, even in a good case where I tell him the law is against you. He wastes half an hour or 1 hour of my time. Why should I use my discretion to you? This, I'm talking to all of you very frankly, from my heart, from what I learned during the 42 years of my journey, 21 years as a lawyer and 22 years on this side of the arena. So dear friends, you are entering into a profession where competition would be too much, where it will be your own hard work, your reputation, and your capacity to deliver good not only to your litigant, but good to the system also, that will determine your future. See, every case that is filed in a court consumes time. And according to the research done by me, even if a case is dismissed by the Supreme Court in 50 seconds or 30 seconds, but from the filing counter, coming to the judge and going back that case consumes 15 to 20 minutes of manpower of the court. And if every day 50 to 60 such cases are filed, what is the man hours lost in dealing with that file? And if that space is available for doing creative work, how much better work can be done? This will ultimately answer the queries of or the anxiety of docket outburst and giving more time for doing work or attending to cases that need more attention. As far as I'm concerned, my innings are over. I have to give the baton to all of you, and I want that you should run the race in a better way and score or run faster than I have done so that the judicial system in this country improves. It's not that we have one of the best judicial system, but there are bottlenecks. As far as your profession is concerned, there are various avenues before you. Now the mediation bill is coming. Maybe that within a few years, mediation would become a profession in itself. Few of you may think of entering into mediation and exclusively practicing in the ADR system. So there are a lot of avenues. But wherever you go, be honest to the profession, be honest to the system, be honest to the person who comes to you for advice, and take care of the system in a manner that the last man in the queue gets justice. I have seen courts in Patna, Bihar, Madhya Pradesh. You will be surprised as to what is the plight of dispensation of justice in those places. When I was Chief Justice of Delhi High Court, the All India Bar Association had called me to make an address. And I said that there is disparity in the dispensation of justice throughout the country. A litigant in place like Delhi or Bombay gets a better quality of justice than a litigant in a remote tribal village of Madhya Pradesh or Uttar Pradesh. The quality of justice is different. Quality does not mean the quality of law. That is also different. Even in the infrastructure available, it's absolutely disparity. There is absolute disparity. The infrastructure facilities available in Delhi are one of the best in the country. And I can show you courts in Bihar where even courts do not have boundary wall. Lady lawyers have to struggle for many things personal to them, and slowly things are picking up. And that is why I say that there is disparity in the dispensation of justice in our country. And I want the younger generation to fight for all these things. Why should a man in a remote village not get justice the way a citizen gets it in Delhi, Bombay, Chennai, or some other place? Now, with the vision of the present Chief Justice of India, we are into virtual hearing. And if virtual hearing starts, I would request each of my younger friends to dedicate some of your time to see that people in the remotest area from where you come also get your service the same way that the litigants in bigger metropolitan and other cities get. Friends, as far as working in this profession is concerned, there is no shortcut. Hard work, reading your brief, understanding it are all required. But I always emphasize to young lawyers that you should be thorough on fact. When the judge asks you a question on fact, it should be in the tip of your tongue. It's not for you to scroll through the pages of your file to know that fact. Left side of our file should contain important dates with fact, And the moment the judge asks you a question, you should be able to give it immediately. All these make a lot of difference in the matter of judging your competency in the mind of the judge. The moment you answer these questions, the judge feels that yes, the young man has or the young woman has burnt her midnight oil and knows the facts thoroughly. I've seen lawyers who start arguing without narrating anything about the fact that, sir, my case is covered by so and so Supreme Court. What is the subject matter? What is the issue involved? They don't say that. I've heard lawyers argue criminal case even without referring to the FIR. The FIR is the most important document in a criminal case. But many lawyers have argued the case without even referring to the FIR. These all makes the judge feel that a wrong impression is created about you. I don't want you to be a victim of all these things. You should prepare your case and then come to the legal issues subsequently. Be thorough on fact. Friends, I think I have spoken a lot. I had a written note, but after hearing Bharat and Kapilji, I said, let me just speak from my heart and share my feelings with all of you. That may help you more than what I have written down, because that you may get in many books and also in the internet. So what I have learned during my journey from during last 42 years, I have tried to put it before you in a small capsule form, in a nutshell, and I hope that it would be helpful in you. Rupam is always in touch with me. Bharat, Kapil sir are all there. Anytime you feel that I have, or you need my guidance or assistance in any form, you're all welcome to contact me. I would love to share my views with you, guide you, and ensure that you get the best in the profession. As I said, I want each one of you to shine in the profession and come out with flying colors. Thank you very much. Before that, I would also like to say something which Kapil and Bharat to hear. I had been in the profession as a lawyer for 21 years and in the High Court for 22 years. But the last 3 years as a chairperson of the Armed Forces Tribunal gave me an experience of my lifetime. I have been dealing with men in uniform. I have seen now very closely how they protect the country, the borders, the sacrifice they do. And today, if we, in this air-conditioned room, I'm sitting and talking to you, and we are having moot court, the credit to large extent goes to the men in uniform who are on the northern borders of our country, the western borders of our country, and they also have a lot of problems. I would request few of you to take note of that also and help the men in uniform also in getting justice. There is a military institute of law functioning in Delhi, which is just like a academy for legal training for the military personnel. And there also we have Moot court martials. I would request associated with dispensation of justice to the men in uniform also, and the Armed Forces Tribunal will always be willing to take your services for certain class of people who need legal aid in the for dealing with their disputes also. So if any one of you is interested in extending legal aid to the men in uniform, please do contact the Principal Registrar of the Armed Forces Tribunal, register the names, and I would recommend cases to you for doing justice to these people. Thank you very much. Jai Hind.
Thank you so much, Justice Rajendra Menon, sir, for your very inspiring words that I'm sure has helped us to understand the profession from your point of view. The experiences that you've shared right now from your life has definitely served as a window for us to peek at the same. And I think most of us present here kind of revisited as to why we wanted to be in this profession as well. So thank you so much, sir. Thank you so much, Liza ma'am. Thank you so much, Bharat sir, and Kapil sir as well. As we approach to the culmination of the segment of this journey, let us not overlook the paramount significance of employing the legal knowledge we have acquired to foster the amelioration of society. Let us ardently advocate for the pursuit of justice and steadfastly uphold the sacrosanct legal framework as the quintessential compass that guides our actions. Finally, we have reached the point that all our participating teams have very curiously awaited for the declaration of results of the second Sankhla and Associates National Virtual Moot Court Competition. With this, I would like to call upon Bharat sir to declare the results of the third runners-up, the second runners-up, and the Best Memorial Award.
All right. So the third runner-up is TAQ 238. That's Law College, Dehradun, Uttaranchal University. Congratulations.
Thank you so much, sir.
Thank you, sir.
Congratulations. Well done. May I now move on to the next one? Yes. So the second runners-up are TAQ 235, which is the School of Excellence in Law, Tamil Nadu Dr. Ambedkar Law University. Congratulations.
Thank you so much, sir.
Thank you so much.
And the best speaker goes to TAQ 207, which is speaker number 2 for the Kerala Law Academy. It's Gauri CV. Congratulations.
Thank you, sir. It was an honor to pray before the bench.
Congratulations. Thank you.
Thank you, Bharat sir, and congratulations to the winning teams. Moving on, I would like to call upon Dr. Kapil Sankhla sir to name the best researcher and best speaker. Best memorial,
Thank you.
sir.
Thank you. First of all, each one of you is a winner. But for this competition, the best researcher goes to TAQ 267, which is Dharamshala NLU, Lakshay Dawar, if I'm not mistaken. Congratulations, Lakshay. And the best memorial goes to TAQ 246, University and School of Law and Legal Studies. Congratulations. My heartiest congratulations.
Thank you so much, sir, and congratulations to the winners. Finally, I would like to call upon Justice Rajendra Menon to declare the runners-up and the winners of the second Sankhla and Associates National Virtual Moot Court Competition.
The runner-up is TAQ 215, Reva University, Bangalore. And the participants were Ashwatha R, Anushka Singh, and Divya Kanojia. Congratulations to
Thank you so
all
much.
three of you.
Thank you so much, sir.
Thank you, sir.
Very good. Very good. The winners are TAQ 207, Kerala Law Academy Law College, Thiruvananthapuram. And the participants are Ren Shibu, Gauri CV, I think she got something, and Aishwarya Tulasi. Congratulations to the team from Trivandrum.
Thank you, sir. Thank
That's
you.
all? Yes. Over
Thank
to
you so
Raini.
much, sir.
Yes.
Thank you. Thank you so much, sir. And very big congratulations to everybody. I would like to now call upon Mr. Rupam Banerjee, sir, founder of the Amicus Curiae, to deliver the vote of thanks.
Thank you, Rani. I hope I'm audible. Yeah, am I audible, Rani?
Yes, sir, you're audible to us.
Okay. Thank you so much, Rani. On this note, on behalf of the Amicus Curiae team, I would like to proceed with the vote of thanks. Today, I'm grateful and enlightened. The keynote address of the second Sankhla and Associate Virtual Moot Court Competition was inspiring. We sincerely thank our distinguished speaker on behalf of the organizing committee, participants, and attendees. Your words inspire us to explore legal expertise and advocacy further. Your insights have revealed the complexity of the legal professions and many opportunities it offers. Your ideas were captivating even in a virtual setting. Your ability to simplify complex concepts and connects with the audience is commendable. Your address emphasizes the importance of the legal education in shaping the future. We appreciate the effort you put into your speech and are honored that you share your knowledge with us. Your dedication to fostering the legal community and mentoring the future legal mind is admirable. I want to thank especially Justice Rajendran Menon sir, Bharat Suk sir, Dr. Kapil Sankhla sir, and Lisa ma'am for guiding us. We are really honored to have you as our valedictory speaker and looking forward from benefiting from your knowledge in the future as well. I would also like to thank all of the judges. We had around 100 judges who judged the preliminary round, the quarterfinal round, semi-final round, and last the final rounds, whose benevolence knows no bounds for graciously bestowing upon us their invaluable time and unparalleled expertise and observations. Your insightful and erudite remarks have proven to be invaluable in argumentating our understanding of legal matters and bolstering our powerness in articulating our stance with utmost efficiency. However, we can't forget the mind which are at the center of this competition to the participating teams. The exciting journey leading to this grand stage has been fraught with challenges and obstacles. You have exhibited not merely your consummate expertise in the legal principle, but also profound capacity to engage in the cognate analysis, articulate compelling arguments, and champion in the ideal of impartiality and justice that form the very essence of our esteemed legal framework. Most importantly, I'd like to advise to all the participants to do keep in mind what our distinguished speaker have spoken and remember this throughout for a successful journey in your respective legal fields. On behalf of the Amicus Curiae team, I wish everybody best of luck in their respective journey and hope to come across you all in some other way. Lastly, I'd like to thank all the organizing team member, the convener Nandakishore, Aratrika, Mugdha, Rayani, Mansi, Sanskriti, all of the OCT members, the court masters, without whom they have been trying hard for the last 2.5 months. And without their support and without them, it would not have been possible for the Amicus Curiae and for us to make it a successful event. Thank you so much once again. And thank you, Kapil Sankhla sir, for supporting us for this particular competition. Thank you so much.
Always a pleasure.
Thank you. Thank you, sir.
Thank you. Thank you.
Thank you, sir. Thank you.
Okay, Kapil ji, Bharat.
Sir, we would be coming and paying you a visit one of these days, sir. We will.
Any day. You're welcome. Just find out if I am in Delhi and you are welcome because I have to go around 10 benches I have throughout the country.
Yes, sir. Absolutely.
Anytime. All are welcome. All are welcome. Okay. Thank you. Thank you, Rupam. Thank you, Rena. Thank you.
Thank you so much, sir, for accepting the invitation. Thank you so much, sir. Thank you.
Thank you.
Thank you, everyone.
Thank you, ma'am. Thank you.
Thank you.
The participants can now deboard the platform. The session is over. The remaining details would be sent to you in the WhatsApp group itself.
Thank you, sir.
Thank you, sir.